And so I think what we are left with is some theoretical universe, however small or large, of cases that for some reason might not be able to be brought before a criminal justice system. The real question that I think, though, needs to be answered before we consider alternatives is at what cost? This is something that was brought up in Amos's presentation earlier. And I think what we have failed to do so far is to take a real close and hard look of what it is that the critics of the criminal justice system are actually complaining about. Are those complaints not in fact, for the largest part, addressed within the ability of the criminal justice system to function? And if there are indeed cases that potentially fall through the cracks, then what is the cost of going to an alternate system? I think when you consider all of those factors, there's an almost inevitable conclusion that it would be potentially disastrous and perhaps nothing more than taking Guantanamo military commissions from Cuba and moving them to the soil of the United States if we were indeed to establish a national security court, taking cases away from the criminal justice system.
Okay, well, I see that Amos has been frantically scribbling some notes, and I'm going to give him an opportunity to respond in just a moment. I do want to commend this particular report, In Pursuit of Justice, to those of you who are interested in this question, because it does take a very comprehensive look. I would add that, I mean, Osama bin Laden himself has been indicted in federal court. One of the interesting things that's happened with the commissions, there's a guy by the name of Gailani who was indicted in federal court, and then he was captured on the battlefield or somewhere, and instead of turning him over to the federal courts, he was taken to Guantanamo and charged with the exact same crimes before the military commission. So that does raise a question of why couldn't we do it in federal court? And one other personal observation from the Al-Balul trial from 2 weeks ago. 3 of the witnesses against him were 3 of the so-called Lackawanna 6. And I just found it very ironic that these 3 guys who were convicted of material support for terrorism in federal court were testifying before the military commission on the same charge of material support for terrorism by my client Ali Al-Balul. Well, why couldn't he be tried in federal court? Since clearly that had been an effective way of prosecuting these particular individuals. Amos, response.
Tom, I want to again thank you, because in essence what you've provided me the opportunity here is to present my proposal and then have responses on all sides. And from my perspective, is what makes it, well, hopefully make the proposal even better, it helps me better articulate it. So I want to thank my co-panelists and all those who came up to me afterwards. It is truly the point of such conferences. With respect to the report that Gabor mentions here, I should have mentioned that when I testified on this proposal in front of the Senate Judiciary Committee, what's his name, Jim Benjamin? Right. So Jim sits next to my right and Zabar sits behind me. I'm not sure he had his back or had Benjamin's back, but he was there. I do think that, again, from not only what George referred to earlier as a cost-benefit perspective, but I think it's deeper than that. If we indeed are, as we are, detaining today thousands of people, and again, not to repeat because time is short, but divide them however you want to divide them. Having talked to Article 3 judges in preparing this proposal, I think it's clear, at least from their perspective, and I think that they're right, that introducing thousands of defendants into the criminal justice process as it exists today is going to lead to the kind of extraordinary backlog and delay in justice that defeats the very purpose of the report, which is in pursuit of justice. And precisely because I really do believe in justice, and justice served, and not injustice denied or injustice delayed. What motivates me in having prepared this proposal is how do we begin the process? I'm the first one to say that there are obvious weaknesses with the proposal. But I think that we need to develop an alternative. And I think that one of the problems with the military commissions process is that it is militarized. I think we absolutely must demilitarize the process. I think from the perspective of the defendant, to be brought in front of civilian judges is absolutely critical. To have lawyers of his choice is absolutely critical. And some of you have suggested during the break that maybe there be a pool of criminal defense attorneys who are qualified or cleared to seek classified information, which would then enable them to participate in the process. I think that's certainly something worth thinking about. I mentioned earlier that Miranda needs to be part and parcel of this. But I think, as I understand the criminal judicial system in its present articulation today is not going to be able to cost benefit judicially, practically, to begin the process of having thousands of people brought to trial, some of whom, with respect to some of whom, there will be a need for the introduction of classified information. I would also suggest, before continuing the discussion, is we don't really have time to waste. I mean, think about this. There are 25,000 people held worldwide on behalf of, or directly or indirectly, some of whom have been held for 7 years. That's nothing more than unconstitutional, indefinite detention. Spin it this way, spin it that way. That's the reality. What's critical is to have this discussion. What's critical is to have other people come up with their suggestions, their alternatives. What is absolutely vital is to understand that the system as it is in place today is unworkable. There's clearly a need to create an alternative.